This is Paul Turner, the immigration barrister at Imperium Chambers. Again, we come back to the issue of Balajigari, and finally the Home Office position in response to the positions filed initially by myself and then upon an extension of time by the other two applicants. We now have the Home Office response. Now, the Home Office response in itself addresses a number of the concerns raised, doesn't agree with all of the points put forward in my previous broadcast. What I intend to do is recap the Home Office's position and then my view and my opinion as to whether or not that they are legally sustainable or whether or not the upper tribunal will actually make directions in favour of the applicants as opposed to those that favour the Secretary of State. Apparently there was some divergence of view in some of the submissions. I think on one case perhaps they intended to, or they desired to carry on fighting the judicial review, but I'm not sure if that's true or not, or whether that is actually still maintained. Anyway, more importantly, the Home Office's position in respect of the various issues, in short, are that all the judicial review should be withdrawn, applicants should get their costs, and they should wait in turn for the Secretary of State to go through a proper Balajigari decision-making process, i.e. put to the applicants in question and give them the opportunity of addressing any concerns that there are in respect of their finances and any discrepancies. In short, the Home Office position is that the applicant should recover their costs. Second, in respect of the right to work, it's expressly stated by the Secretary of State that anyone that's made a request for the right to work has been granted or will be granted the right to work. I'll come back to that later. Finally, then there's Section 3C leave, or not finally, penultimately Section 3C leave, which relates as to a request that individuals be given Section 3C leave. The Secretary of State's position is Section 3C leave is a matter of law, that if you made an in-time application and the decision is quashed, that you would automatically have your Section 3C leave come back to life. It's not an issue where the tribunal can grant Section 3C leave to individuals who made out-of-time applications, say an application for ZLR after the admin refusal and after their leave has expired. The Secretary of State is also not willing to provide a letter absolving individuals of dishonesty, and there'll be no immediate right of appeal for all the cases caught up in the JR cohort. Individuals will either have to make a paid for application if they wish to make a human rights claim or have their matter reconsidered. And lastly, in respect of those that voluntarily departed or left the United Kingdom, the Secretary of State does not agree to facilitate their return, but says that if they're successful in the reconsideration and they win their application, then the Secretary of State will do all in its power to ensure their return. Now, as to my view on the matter, in respect of the costs, well, it's only natural and right that individuals that have gone to a great time and trouble and money should recover their costs for the judicial review proceedings. To suggest otherwise would be an absolute nonsense. As to the right to work, the Secretary of State says all those people who have asked for the right to work have been granted the right to work. And that doesn't necessarily chime with my own personal experience, where there are individuals that have had applications for the right to work outstanding for a considerable period of time and have received no response. Paul's there to say that if you haven't received a response, it might be time for a pre-action letter relying on the Secretary of State's position statement. I would also note that in light of my previous broadcast, that if you have an application for the right to work, send it to the Capitol building in Liverpool. I'm sure your representatives will give you the address and not to the GLD, because as I've said, they're probably sick to the teeth of receiving a request for right to work and then forwarding it on to the Home Office. Section 3C leave, that's a tricky one. One can understand individuals wanting to have Section 3C leave, wanting to have the ability to work, but if the application is made without time, then that can cause a problem. However, because it's unlikely in my experience that the upper tribunal will grant people who made out-of-time applications Section 3C leave, because that would A, mean that the upper tribunal are rewriting the law because an individual who doesn't have leave and therefore can't be granted leave unless their application is successful. And that's a bold step for the upper tribunal to take, and one that I think they will shy away from. And B, it also sets a precedent that anyone that succeeds in judicial review in respect of an out of time application would also be entitled to have their Section 3C leave extended. There is perhaps a complicating matter in respect of Section 3C and the interplay with the right to work, which is that what's happened is I've seen letters indicating that the individuals are essentially liable to detention under paragraph 16 of Schedule 2 of the 1971 Act, and are granted bail under Schedule 10 of the 2016 Immigration Act, and then it says that they're granted the right to work and right to study. This might on the face of it look a little unfair, but it does confer the right to work. However, experience has shown that actually when individuals carry out and prospective employers carry out a check on ECS, the Employment Checking Service, it says that there is a restriction on the right to work and that the right to work is only granted for 6 months. Now, in my view, that's fundamentally unfair, because if I was an employer and I was looking to take somebody on and invest into the time and training of the individual and then look to the return afterwards that they could give me as a valued employee, I would be extremely reluctant to take somebody on unless it was for a very casual job, and a lot of the applicants are highly qualified, because there's no guarantee that the 6 month period will be extended. And so therefore, whilst in theory it grants the right to work, it's limited, and I've objected to that on the basis for those reasons, that it's limited, that it indicates, if one produces the bail document, that the individual is subject to detention and has only been granted bail, as opposed to the fact that in reality the Secretary of State made an unlawful decision, has put these people through a great deal of discomfort and suffering. And in my view, the Secretary of State could have been somewhat more lenient, and ought to be more lenient, and the upper tribunal will hopefully endorse that view in saying that the right to work should be unfettered and should be for an indeterminate period of time. If individuals win their applications, then they'll get their indefinite leave to remain or another type of leave, and if they don't, then they'll lose their right to work. But it shouldn't be that they're essentially given a limited right to work, and the Secretary of State's position paper doesn't make that clear, and that's something that I will take up. Now, the no immediate right of appeal, that's a tricky one, because if you made an application under the immigration rules, then there isn't a right to work, there's a right for admin review. If you made an application for leave to remain or SETLR or what have you, a vast number of individuals will have been granted the leave to remain or SETLR and granted right of appeal rather. And I've represented, my colleagues have represented a number of people, often quite successfully, before the first tier tribunal. But the Secretary of State's position is essentially, if you want to make a human rights claim, you can pay for it. My previous advice, going back to probably when I started making these broadcasts, was that if you have an outstanding application, vary it to SETLR, so that you stand a better chance of getting a right of appeal. And then the last point that I really take issue with, which is the voluntary departure. Now, in theory, once one has a refusal without a right of appeal, one becomes an overstayer, and therefore one commits an offence under, I think it's Section 24(1)(b), I think, of the Immigration Act 1971, in remaining in the United Kingdom, notwithstanding the lodging of a judicial review that's ultimately been successful, and the Secretary of State accepts that the individuals have succeeded. So individuals that have either gone back as per the immigration rules and the Secretary of State's exhortations to go back, or those that have been forced to go back due to the hostile environment and the pejorative cost of maintaining a judicial review application and living in the United Kingdom without a right of appeal, ought, in my view, to be facilitated to return to the United Kingdom prior to any consideration. The Secretary of State's position is that they should have their case, that if they win the reconsideration or they win their application, then they'll be allowed back into the United Kingdom. In some ways that's perverse, because the whole reason that Balajigari succeeded was that the Secretary of State didn't give individuals the proper opportunity to file evidence and to rebut the allegation of dishonesty. Now, if an individual's in the United Kingdom and they go to see their lawyer after having had the decision set aside, they might choose to vary the application to a set of our application if they qualify, which may carry with it a right of appeal and a better chance of success. That's obviously not open to individuals that are outside the United Kingdom. But more fundamentally, if an individual wants to stick with an application for leave to remain under Set O, or the application that was originally made, then it's going to be very difficult, in my view. Whilst the individual who's in the United Kingdom can perhaps see their accountant, can perhaps take legal advice, can obtain medical evidence and put together a comprehensive response to the Secretary of State's allegation of dishonesty, that's simply not open to those that have voluntarily departed and are perhaps living in, say, Pakistan, India or Bangladesh. I mean, I'm not quite sure how the Secretary of State can fairly reconsider their case in line with the decision of Balajigari if these individuals are living 7,000 miles away. I really simply don't see how the Secretary of State can do it. Perhaps the Secretary of State thinks that by having a quick telephone conversation and asking them a few questions, that will suffice in respect of Balajigari. That creates two types of people: those that are in the United Kingdom and have the opportunity of gathering all the evidence and putting it forward, and those that have to try to do so from a long way away with the various different difficulties that there were or are in communicating with lawyers and communicating with the UKVI and persuading the Secretary of State that they weren't dishonest. I mean, you'll recall that in the TOEIC cases, they found that an out-of-country right of appeal, and by analogy, the out-of-country right of appeal is to prove that the person was innocent. By analogy, an out-of-country opportunity to explain that you're innocent is going to be far less effective, in my view, than somebody who's remained present in the United Kingdom. So individuals that have followed the law and have left the United Kingdom ought not be prejudiced and should be treated the same, and therefore should be invited back into the United Kingdom so that they're able to address the Secretary of State's concerns if the Secretary of State does do what Balajigari says and makes a proper decision by giving the individuals the proper opportunity to rebut any allegations of dishonesty. So there you have it. The short point is the Secretary of State accepts that they've lost, agrees to pay costs, but wants the individuals to withdraw their judicial review and has made limited concessions. You've heard my concerns as to those concessions. I've made submissions in respect of that. The matter is now before the upper tribunal, who will either issue directions, or there's the potential, if they don't issue directions, for there to be a further hearing, though whether that happens or not I cannot possibly say at this potential stage. What I will do is I will update you if you upon receiving any further news, and I hope that this relatively short broadcast has been of some interest. If you have any immigration problem whatsoever, please do not hesitate to contact me, Paul Turner, the Immigration Barrister at Imperium Chambers, on 0207 242 3488, or at clerks@imperiumchambers.co.uk, or at my site, The Immigration Barrister. Once again, thank you for watching. This has been Paul Turner, the Immigration Barrister at Imperium Chambers.